rather than to ensure the system is fair for everyone. How far will they go? What is next? See, they have used the courts to rip up the constitutional protection for a woman's right to make her own healthcare decision. They have used the courts to throw out all kinds of common sense gun violence prevention measures, doing the bidding of the gun lobby. They have used the courts to attack fundamental tenets of our democracy, the Voting Rights Act, and the ability of the people to choose their representatives rather than the other way around. So, Ms. Clark, you actually touched on something that I'd like you to elaborate a little bit more on, which is how the court system is used and abused by large corporations and powerful special interests in ways the average person does not have access to.
Congresswoman Brown, as I mentioned in my testimony, the revelations over the last 6 months from journalists indicate that some members of the Supreme Court have accepted repeatedly rather lavish gifts from very wealthy patrons. And this practice of one might say fraternizing with this group, including, at least in a few cases, people who have matters before the court or whose interest could be affected by court decisions. This phenomenon absolutely undermines public trust in the Supreme Court. So I would just say that's why I think it's important for there to be an institutional response rather than simply vilifying the justices who have engaged in this behavior.
Thank you so much. Well, I want to end by echoing Ranking Member Raskin and a call for a hearing on judicial ethics and conflicts of interest posed by Justices Clarence Thomas and Samuel Alito receiving gifts from GOP mega donors who have business before the highest court. I would think these significant issues of actual, proven conflicts of interest would be of the utmost concern of my Republican colleagues, given the time, attention, and resources this committee has dedicated to futile, fabricated, and reckless rumors about the president, which I will happily remind everyone have been a dead end every single time. And with that, Mr. Chairman, I yield back.
You can yield back, but that statement was completely false. We're not going to strike it from the record because it's your opinion. You can have an opinion, but bank records don't lie. You should go to the Treasury Department and read, like we have, the 150 bank violations from this family. And I am excited about this committee's newfound.
For indictment.
You want to go, Ms. Crockett?
91 counts.
That what?
4 indictments, 91 counts.
We are very excited about your newfound desire and concern about influence peddling. And to answer your request, we're going to have plenty of opportunities to talk about influence peddling, and you're more than welcome to bring up the Supreme Court. You're more than welcome to bring up the previous administration.
Just point of order, Mr. Chairman. Just
state your point.
But where exactly are we in the order of things? Whose time is being used right now?
Well, we are now yielding to me. It's my time. I ask questions. Ms. Wing, I think it's important, the purpose of this hearing. Can you briefly summarize how third-party litigation funding works? Because I don't think everyone understands that.
Congressman, based on my experience, what's happening is that law firms will contract with third-party litigation funders, get a significant amount of cash from them, use that money to generate huge media and advertising campaigns alleging that a product is defective. They then collect those cases, sell those cases, funnel those cases into a multi-district litigation, and wait around for settlement. What's very interesting about this, Congressman, is that there is no transparency, no disclosure, and no, to the Congressman Armstrong's point, no ethics obligations between the funder and the ultimate claimant, which is what's so troubling.
How long has this been going on? And I assume this is a very fast-growing industry because of the rate of return that you mentioned in your opening statement.
Yes, Congressman. Globally, it's estimated that the litigation funding is about $39 billion, within the U.S., about $13 billion of assets under management.
I would say that the overwhelming majority of investors, if not 100%, are institutional investors, or in other words, high net worth investors.
Hedge funds, private equity, and just pure litigation funders.
Right.
Again, with no transparency, no disclosure, defendants don't know who's negotiating at the table, defendants don't know who has control over the litigation, neither in many cases do the actual claimants, because there is no disclosure requirement.
Yeah, this is the purpose of the hearing. We're certainly learning about this industry. This is something that has an impact on consumers. It has an impact on the entire judicial system. As we know, we're bogged down and behind in these cases. How much do frivolous lawsuits, would you say, cost the average consumer for prescription drugs? Do you have any idea?
Congressman, that's a very hard number to give you. I don't have that at my fingertips. But what I can tell you is that over the last 10 years, with the introduction of third-party litigation funding into the pharmaceutical and medical device mass tort litigation sphere, we've seen an exponential increase in the number of claims. And also, as I mentioned in my opening statement, about 20 to 30 to 50% of those claims are entirely meritless and don't belong there.
And I would assume that a big company like yours, if you have to pay out a lawsuit or a frivolous claim, that you just pass that on to consumers, because one of the biggest issues in America right now, and the polling shows that, is inflation. And the cost of healthcare is certainly a big part of inflation. And we're going to have a hearing next week on the pharmacy benefit managers, an area where I think the majority of this committee actually agrees on, which is great that we actually agree on an issue. So I think this is something that we need to continue to study and evaluate, and try to determine through probing what this costs and the impact on the overall judicial system. Ms. Lucas, we're concerned also about energy policy in America, and there's a push by this administration, and quite frankly, there's a lot of consumers that want to have electric vehicles, for example. To be able to be successful in converting to electric vehicles, we're going to have rare earth minerals. And your state has an abundance of reserves, but it's my understanding that because of lawsuits, it's become very difficult to get permits and to mine. Can you briefly kind of give us a summary of what's going on in your state?
Yes, so we are primarily copper, nickel, platinum, palladium, gold, cobalt,
Which are very important for batteries.
which are very important for batteries. Our one project was permitted, or I'll say our front-running project was permitted in 2018 and 2019, and they are still tied up in litigation.
So where are we getting those rare earth minerals for the batteries that Ford and Toyota are in the process of building massive plants, one in my home state? We're very happy to have that investment, but where are they getting the rare earth minerals?
Not from my state.
They get them from China, from Africa,
China,
from
Africa.
Right. And that's a problem. And as we move forward and talk about energy policy and the push for electric vehicles, I'm fine if the market wants that. I'm a free market guy. But I'm concerned about the capacity of our grid. I'm concerned about our reliance on China, because China has been purchasing many of these rare earth mineral mines in Africa, and it's a concern. So this is something that we need to communicate further about to see what we can do to assist in helping utilize our own resources, our own rare earth mineral mining, and all of the capacity and potential we have in the United States. Chair, my time's expired. Chair, now recognize Ms. Stansberry from New Mexico for 5 minutes.
Thank you, Mr. Chairman. And I'm grateful that the Oversight is having a hearing today on judicial activism and dark money influences, especially when we're seeing one of the most corrupt dark money influence courts ever in American history. Of course, I'm disappointed to see that the chair and the GOP majority, as usual, has been propping up these dark money actors and calling industry witnesses to testify at this hearing today. It is, as the ranking member said, truly a moral and, I believe, constitutional crisis in our legal system, as we're seeing a Supreme Court and justices who are taking lavish vacations and kickbacks from wealthy donors, hearing cases that are funded directly and indirectly by right-wing donors and organizations, and in the process, systematically gutting the American judicial system and undermining our fundamental rights. Rights like the right to control our own bodies, to be safe in our communities, and rights to live free and healthy lives in our communities. So as they say, let's follow the money. First, let's start with abortion and reproductive rights. As we know, last year, the Supreme Court handed down the Dobbs decision, which upended 50 years of settled law protecting our right to control our own bodies. And who funded this litigation? Organizations like the Alliance Defending Freedom, bankrolled by organizations like Leonard Leo and Harlan Crow. Yes, that Harlan Crow, who we know has been whining and dining Supreme Court justices for years. Second, let's talk about the right of our tribal nations to be sovereign and to protect their communities. Last year, the Supreme Court handed down the Castro Huerta decision, gutting federal recognition of tribal sovereignty in criminal jurisdiction and overturning over 100 years of settled law, and agreed to hear a case involving the Indian Child Welfare Act and the right of tribal communities to control who can adopt children from their own communities. Who funded these efforts against the Child Welfare Act? It was organizations like the Goldwater Institute, funded by the Koch brothers and the Mercer family, which, as you all know, has direct ties to organizations and folks like Betsy DeVos, who tried to gut our education system in the Trump administration, and the Pacific Legal Foundation that's funded by companies like ExxonMobil. Can you imagine dark money organizations suing to take indigenous children out of their communities? I mean, it doesn't get much darker than that, does it? Really? Finally, let's talk about our right to clean water. You know, that basic right to live. Months ago, the Supreme Court gutted the Clean Water Act when they handed down the Sackett decision. Guess what? This case was funded in part by groups like the Searle Foundation Trust and Donors Capital Fund, which poured money into that case from organizations and donors also tied to Leo, Mercer, and the Koch families, and organizations which have been actively undermining climate action for years. And at the end of the day, it resulted in a decision that the court handed down that essentially said that our rivers and streams and wetlands shouldn't be protected, including over 90% in the state of New Mexico, which I represent, going even further than Donald Trump went in gutting the Clean Water Act. So if the majority wants to talk about dark money and activist courts, I am so here for it. And let's talk about the ways that it's actually undermining our fundamental rights, our Constitution, and our judicial system right now in this country. Because I have to say that I have never in my lifetime seen a more activist court and a court that is more influenced by dark money than what we're seeing in this country right now. And I believe that it is one of the most significant threats to our democracy. So let's talk about it. That's what we should be talking about today. Not a bunch of industry folks sitting in front of us talking about frivolous lawsuits. And that is why we need to be reforming the courts, enforcing judicial ethics, and removing judges who violate their oath. Because literally, our democracy and our rights as a country depend on it. And I yield back.
Gentlewoman yields. The gentleman from Florida, Mr. Donald, is recognized for 5 minutes for questioning.
Thank you, Mr. Chairman. I think it's important to first note out for the record that the use of quote-unquote dark money, especially since 2020, has actually been dominated by my colleagues on the other side of the aisle. The New York Times has reported on this. The Hill has reported on this, that most dark money, whether you want to talk about the court or politics or whatever the case might be, actually comes from the political left and the Democrat Party. And it's not been written about in the pages of the New York Post. That comes actually from publications that typically lean left in the United States. Real quick, Mr. Chairman, I want to actually kind of change speeds a little bit in some of what we've been discussing and do talk about some potentials that may exist affecting our judicial system. This is really for all the witnesses. Are you aware of any specific examples or instances of the Chinese government paying American law firms to sue for certain causes that would actually embolden the CCP's policy here in the United States? Anybody?
Congressman, thank you for the question. I am not. However, the reason for that primarily is because we don't have access to third-party litigation funding agreements. We don't know, in many cases, who's funding these litigations, and that's why transparency, disclosure, regulation around this industry is so very important.
Okay, thank you for that. Quick question on follow-up on that one is: do you guys believe that third-party litigation has the potential to discourage and hamper American innovation?
Absolutely. I would look at the Gulf of Mexico as one of the most premier innovative energy hubs in the world. We're ready to deploy carbon capture and storage. We're ready to invest in hydrogen, offshore wind, oil and gas. We can do it all. But every one of those forms of energy, whether it's oil and gas, wind, carbon capture and storage, is subject to litigation, and that threatens the ability of the U.S. to be the leader when it comes to deploying and advancing new technologies, and it sends that overseas. Our companies are doing it, they're ready to do it, and they want to keep doing it, but the court system holds it up.
All right, let's build off that a little bit, because one of the main topics when you're talking about some of the renewable energy sources is also deals into critical minerals, and rare earth minerals are part of that. We know that China basically controls the green tech supply chain. No matter how we want to talk about it here in the United States, those are the facts. Do you believe that China is a vital linchpin in the solar and wind supply chain in the United States?
Yes, thank you for that question. Right now, the vast majority of our renewable energy technologies come from China, and we have very limited manufacturing capability in the U.S. I'm proud to say our state has one and soon to be a second solar panel manufacturer, but a lot of their materials are still coming from China, and I hope we can be honest about that and think about how we change that situation.
If we took China out of the supply chain equation, can the United States currently build an offshore wind farm? Mr. Miloto. Sorry.
We're moving in a direction of being able to do more and more of that in the U.S. We're building manufacturing plants. Well,
hold on, real quick. Because one of the things in Congress we hear a lot is, and it's not just here in hearings, we hear it in meetings all the time, we're positioning ourselves, we're on our way to do that. Today, if China was removed from the supply chain equation, could we today build an offshore wind farm?
I don't know, to be honest.
I would actually probably say that if you don't know, then the answer is there's no way it's going to happen. In your personal opinion, do you think prices of the electricity generated from offshore wind would go up or down if the United States had the capability of domestically mining important minerals and the ability to manufacture critical components? So if we basically did it all internally here in the United States, do you think the cost per kilowatt hour would go up or down?
The movement of the sector continues to drive costs down because of efficiency and cost effectiveness over time, and the scale is driving toward greater and greater efficiency. So doing it in the U.S. should not slow that down.
Okay, all right. Listen, I think that's all I need right now. I think one of the things we should be concerned about, and Ms. Wayne, I think you said it initially, is that one of the issues we are clearly seeing with third-party litigation is that there are, quote-unquote, dark pools that are funding all kind of lawsuits on all kind of sides of the aisle. And I do think that there is some levels of transparency that we need to find around this, because we shouldn't be using the civil litigation system to create policy that frankly belongs here in the halls of Congress and in state capitals across the country. With that, I yield back.
The gentleman yields. The gentleman from Florida, Mr. Frost, is recognized for 5 minutes for question.
Thank you, Mr. Chairman. In my district in Central Florida, I've met with countless families, children, and seniors whose lives have been devastated by the opioid addiction and epidemic. In 2019, a driver in a community that's in my district called Bithlo pulled into a stranger's driveway, abandoned the car, and in the car left 2 overdosed women in the back. When they found the car and they found the women, they were barely breathing. I'll say recently, thanks to the tireless work of folks like Project Opioid, Transformation Village, leaders like Tim McKinney, and other local organizations in Central Florida, things are trending in a better direction, but it's still dire. And Republicans are showing us today exactly what they actually care about. Today, they've had the chance to hold big corporations accountable for the damage they've done to our communities, but instead of looking into that, have invited big corporations here to air their grievances about how everyday Americans are bullying them. This is supposed to be the Oversight Committee, and so far, the only oversight we've done is into the municipality of Washington, D.C., into the president, nothing coming out of that, seeing Hunter Biden's dick pic. I mean, this is the stuff we've been doing here. And recently, more than 100,000 people have died from opioid overdoses in 2022, and pharmaceutical companies that push prescription opioids were partly responsible. In the lawsuits that followed, Johnson & Johnson were forced to pay $5 billion in a settlement. Following that very public settlement, for some reason, Johnson & Johnson decided it would be a good idea to send their Assistant General Counsel to Congress to complain about these and other lawsuits that Johnson & Johnson have been a part of. Johnson & Johnson have a market cap of over $400 billion. The 2021 lawsuits and the countless Americans who were impacted by the opioid epidemic only set Johnson & Johnson back a cool $5 billion. Yet today, my Republican colleagues turn a blind eye to the opioid crisis. They rather use the gavel to amplify corporate demands that seek to deny Americans access to the resources needed to hold corporations and companies like Johnson & Johnson accountable. Of the $26 billion that 4 major drug companies agreed to pay for their role in the opioid epidemic, about $2 billion went towards lawyer fees. Now, in this community in my district of Bithlo, the per capita income is roughly $30,000 a year. Ms. Steinmetz, I have some pretty straightforward questions for you. If someone in Bithlo, in my district, had a family member that was mismarketed opioids and suffered life-changing addiction or even worse, death, how would they normally seek redress from the pharmaceutical companies that were partly responsible for the mismarketing?
Through lawsuits.
Through lawsuits. If they got into this lawsuit, could they represent themselves?
They would need counsel.
But they have the right to also represent themselves,
Yes,
correct?
they have the right to represent themselves.
Against an army of pharmaceutical lawyers, how would that go if someone was representing themselves, if they didn't have the means necessary to accrue tens of thousands, hundreds of thousands of dollars in lawyers' fees?
Per se litigants who represent themselves are rarely successful.
Rarely successful. Many of these lawsuits are complicated and last for years, right? I mean, you know, how do you think one of my constituents in Bithlo making 30 grand a year would be able to afford tens of thousands, $100,000 in lawyers' fees? Do you think that might be possible for them or no?
I do think that plaintiffs should be able to access financing, whether it's through the contingency fee or through third-party funding litigation. I do have a concern that sometimes these people are the ones who are preyed on the most.
And Ms. Steinmetz, last question. In civil cases, if someone who needs to file a lawsuit can't afford an attorney, is there a constitutional right that one be provided to them?
In civil cases,
In
no.
civil cases, no, there's not. By holding this hearing, Republicans on this committee have shown that they care more about putting profits over people, that they care more about perpetuating a myth that people in communities around the country who have been exposed to toxic chemicals, sold contaminated baby powder, and flooded with opioids in their communities are demanding too much by demanding justice. These folks are not the villains. The American people are not the villains. They are people in our communities fighting back against wealthy corporations, and they're the real heroes. And to Johnson & Johnson, I want to say loud and clear, you paid $5 billion for your role in the opioid epidemic and acknowledged no wrongdoing. Number one, there was wrongdoing. Number two, it should have been a hell of a lot easier to take Johnson & Johnson to task, and I think they should have had to pay a lot more money. Shame on Republicans for holding this hearing to vilify the people who are helping poor and working class Americans level the playing field and stand up for themselves. Thank you, Mr. Chairman. I yield back.
The gentleman yields. The gentlewoman from Michigan, Ms. McClain, is recognized for 5 minutes for questioning.
Thank you, Mr. Chairman. And I first just want to share my excitement that my colleagues on the other side of the aisle are so concerned about ethics. I'm extremely excited to hear about that. Since this committee has uncovered that the Biden family has received over $20 million from foreign nationals, and they can't say one thing they did to earn that money. So I'm looking forward to this ethics talk. But I'd prefer to talk about something that maybe we can agree upon and move and get some clarity around. I think we all can agree that the lack of transparency in third-party litigation funding is concerning, whether it's dark money on either side, right? That's never a positive. The lack of monetary reporting requirements in third-party litigation funding opens the door for foreign entities, this is my concern, for foreign entities to influence the U.S. court proceedings for their own political and perhaps monetary gain. Foreign adversaries could access, I believe, privileged information, including sensitive government information, patents, or confidential business information via the litigation process because of the lack thereof of transparency. So my question, Professor Steinitz, is, are there loopholes in the current legal system by which a foreign adversary, such as China, could gain access to highly confidential information via the discovery process?
The discovery process does allow litigants to seek the information of their adversaries, and so that is a possibility.
Okay, so yes, so we should all be concerned that there are loopholes that our foreign adversaries could gain access to critical information that may end up hurting us. Could this impact U.S. companies' intellectual property or even our national security with this information that they could obtain?
It could happen in any individual case. I don't know that we have a systemic problem with that, and there are no reported cases of that sort, but it is a scenario that could come to pass.
Okay. Do you believe that updating reporting requirements, disclosing lawsuit funding sources could be a potential remedy for this situation?
Yes, clarifying under what conditions third-party funding should be disclosed would be helpful.
Let me ask my question in a different way. What would the harm be in updating the reporting requirements for disclosing lawsuit funding? What would the harm in that be?
The harm could be if there's over-disclosure. So, for example, requiring plaintiffs to disclose how much finance is available for them to pursue their claim is oftentimes not relevant and can be misused in a given litigation context.
Thank you. In 2022, 14 state attorney generals sent a letter to Merrick Garland that stated foreign countries such as China and Russia could use third-party litigation funding to fuel targeted lawsuits designed to weaken U.S. national defense companies in the business of protecting our national security interests. Likewise, costly litigation aimed at sabotaging major energy sectors that are vital to our economy poses a direct threat to our economic security interests and global independence, end quote. Mr. Melito, can you explain how costly litigation is already impacting our economic security and weakening our energy independence?
Yeah, the U.S. has risen from being energy scarce back in 2009, producing like 5 million barrels a day to close to 13 million barrels a day. And that's shaken the world markets. Geopolitically, we're in a much more powerful position today than we've ever been in when it comes to energy. And we could see Ukraine, Russia, how Russia uses it. We know China wants to dominate energy, and Iran, Iraq, you name it, they use energy as a tool. So when we see efforts through the court system to constrain U.S. energy production, we're providing, a shift in those benefits and a shift in that geopolitical control to our enemies. And it hurts us from a national security standpoint because energy security is national security, and these are long-term needs that we have, and when we fail to replenish our oil and gas potential through leasing and other activities, we're really hurting us for near-term, mid-term, and long-term.
I believe the lack of transparency in third-party litigation isn't only a threat to our legal system, but clearly a potential threat to our national security. And I'm out of time, so I yield back. Thank you.
The gentlewoman yields. The gentleman from California, Mr. Garcia, is recognized for 5 minutes for question.
Thank you very much, Mr. Chairman. I want to thank all of our witnesses for being here today. And it's apparent that we're here today because our Republican colleagues are worried that it's too easy for the American people to bring legitimate claims against big corporations that poison and pollute our communities. And as they put it in their press release when they announced this hearing today, they're concerned that, quote, financiers are hijacking America's courtrooms. Now, I think my colleagues, of course, might be projecting. Big corporations, as we all know, are doing just fine. Meanwhile, Republicans are willfully ignoring the fact that wealthy conservative donors are lavishing gifts on the conservative justices of the Supreme Court. So if they want to talk about money in the court, let's talk about Justice Clarence Thomas and the many allegations of ethical lapses and conflicts of interest that came to light just a few months ago. So we're going to keep this simple. Now, first, I have a photo here. We see Justice Thomas with his very generous friend, Harlan Crow, who we've heard a lot about. We know that Crow is the conservative billionaire who has poured enormous amounts of money into Republican causes, funded right-wing advocacy organizations, including those, of course, run by Justice Thomas's wife, Ginny Thomas, who has had, of course, cases before the court. Now, some of these gifts that have been given to Crow by Thomas, let's list those. Justice Thomas regularly stays at Harlan Crow's private lakeside resort in New York, which I hear is very lovely. In 2017, Justice Thomas stayed at the resort with fellow guests from Verizon, the American Enterprise Institute, and PricewaterhouseCoopers, to name a few. In 2019, Justice Thomas flew on Harlan Crow's private jets and enjoyed 9 days of island hopping in Indonesia on Crow's 160-foot yacht, which I've never seen a yacht that large. I'm sure it's very lovely. It came with servants and private chefs. If Justice Thomas had actually chartered that yacht himself, it would have cost him $500,000. Now, Justice Thomas also accepted a $19,000 Bible that from Harlan Crow, of course, that once belonged to Frederick Douglass. And apparently, so this must be the same Bible that the justice is using to take away rights from women and gay people. Now, Harlan Crow's foundation also made a over $100,000 donation to Yale Law School for the Justice Thomas Portrait Fund. Now, Harlan Crow purchased Justice Thomas' family home and a property where Thomas's mother has lived rent-free. And Thomas Crow also paid the boarding school tuition of Thomas's grandnephew, Harlan Crow, valued at over $100,000. So the list, of course, goes on and on and on. And if this isn't corruption, I don't know what is. Now, Professor Clark, I want to thank you for your testimony today. How was Justice Thomas able to accept these lavish gifts? And how is it possible that a sitting Supreme Court justice can take so much without scrutiny?
Congressman Garcia, Supreme Court Justice Thomas has engaged in this practice of receiving these lavish gifts, as you outlined. And even more disturbing, in my view, is the fact that he failed to disclose those gifts, or many of them. And he has gotten away with failing to disclose until these gifts and other inaccuracies were discovered by journalists or other non-government organizations. So there is a lack.
And we're to assume that Justice Thomas is trying to keep these things hidden from the public. I mean, he did not disclose his gifts. Was that your assessment?
Yes, it is true that he did not disclose these gifts.
And so what he chose not to disclose was traveling on lavish large yachts, was being treated to the best food, was traveling in Indonesia, was getting $20,000 Bibles, was gifts to his favorite charities, and he chose to not disclose any of these information to the public. Is that correct?
Congressman Garcia, I believe that the Bible may have been included on one of his
Good for him. That's good for him.
I think that everything else you mentioned, he did not disclose until called to account.
Absolutely. And of course, we know the issue, of course, is not just the gift themselves, but it's actually the disclosure process. We also, another issue is that some of these gifts have had connections to cases that have been in front of the justice himself. And so these are with other business interests tied to Mr. Crow. Now, Republicans claim to be concerned with outside money influencing the legal system, but only when it hurts their corporate backers. When right-wing billionaires create conflicts of interest for the highest court in our country, they are completely silent. So I look forward to the many hearings that we have on Clarence Thomas and the justices and their illegal gifts that they're receiving and not disclosing. Now, this is what happens when we combine big money donors with weak judicial ethics rules. We must do more to bolster the integrity of the Supreme Court. I want to thank Ms. Clark for your work in these efforts. Like all of us on our side of the aisle, we want to put the American people before corporations and put the Constitution above conflicts of interest. Thank you, and I yield back.
The gentleman yields. I recognize myself for 5 minutes for questioning. Mr. Melito, I'm going to be questioning you, but first, Ms. Swan, may I suggest to you, Madam, I would likely not be welcome on one of your boards, but let me just say I think that this would be solid advice regarding veterans and our elders. Just give them the drugs that they need. Talking about maybe 75 million Americans. Most of them don't use a lot of medicine, and most of that medicine is not super expensive. Just going to go on record saying this is common opinion of a regular American across the country. Big Pharma has challenges with reputation, hearings like this, and unending lawsuits, billions of dollars. Billion is 1,000 million. You know, Americans can't get their heads wrapped around that. And meanwhile, you got veterans, you got our elders struggling to get drugs. Just give them what they need. You'll find it to be a win. Mr. Melito, you familiar with the Rice's whale situation?
Yes, sir, I am.
I'm going to be questioning you on that. America suffers from a toxic legal climate for industry and insured businesses. This is well known, and litigation is a particular specialty of the modern era's weaponization of the executive branch against American citizens. When you have federal departments and agencies like the EPA, DOL, and NOAA working with activist organizations and recruiting and in many cases training plaintiffs, and those plaintiffs file lawsuits, then they sit back and wait for their settlements. It's quite a racket going after the transportation industry, our airports, our maritime ports, and oil and gas industry, agriculture industry, community banks and credit unions, trucking, rail. It's a growing racket, and it's disturbing. So today's hearing is entitled Unsuitable Litigation, Oversight of Third-Party Litigation Funding. And we're going to dive into something called the Rice's Whales regulation through litigation, as you referred to it, Mr. Melito. So by background, earlier this year, a coalition of environmental protection groups filed a petition with the National Oceanic and Atmospheric Administration, NOAA, to establish a year-round 10-knot, that's about 11.5 miles per hour, vessel speed restriction zone and other vessel-related mitigation measures in the Rice's whale core habitat area, which is a large swath of the Gulf of Mexico. So for Americans watching, you're talking about whales that were essentially determined to use that area as their habitat just a few years ago by NOAA. This is the major corridor for commerce in the Gulf of Mexico. They're talking about keeping vessels at under 10 knots and talking about them not operating at all at night. It would be like a death blow to American industry. You think inflation is bad now. If these rules go into effect, it's going to be exponentially worse. So, Mr. Melito, you stated that the agreement does two things: removes millions of acres from the upcoming offshore lease and sale in Gulf of Mexico for oil and gas, and places new unwarranted restriction on oil and gas activities in that region, and targets things like vessel speed. Explain to America, please, why this example of regulation through litigation is bad for every American.
Well, right now, it's preventing our industry from being able to produce the energy that our country relies on for a high quality of life. It impacts jobs for everyone along the Gulf Coast and in states throughout the country that support that region, and it eliminates the ability for the government to get billions of dollars in funding for Land and Water Conservation Fund, urban parks and recreation, for coastal restoration, national parks. It has a huge impact on that. That's just a short term. In the long term, you're looking at an entire barrier put across the entire Gulf of Mexico, from the Texas-Mexico border all the way around to the Florida Keys, where vessels are going to be impacted in a way that that whole region is going to have its commerce disrupted, and that'll ripple through the U.S. economy.
Thank you, sir, for that clarification. Ms. Wine, did you like to respond to my suggestion for your board?
Congressman, thank you for the suggestion. Johnson & Johnson believes in accessible and affordable health care. As evidenced by the fact that our net prices have declined for the past 6 years. I urge you to look at our 2022 transparency report that's available on our website, but I thank you for the comment.
Yes, ma'am, and thank you. And I urge you and your company to look at American veterans and elders through a special light. They're treasures for us. Let's take care of them. I yield. I yield, and I move to Ms. Lee from Pennsylvania is recognized for 5 minutes.
Thank you, Mr. Chairman. While I'm thrilled with any and all opportunities to talk about judicial ethics, I also find it very telling that my Republican colleagues only want to discuss it when corporate CEOs are the so-called victims, not when dark money funded and fueled the overturning of Roe, or the rollback of LGBTQI plus protections, or the reverse of student loan relief and the end of race-conscious college admissions, not when it was revealed that two of our most right-wing Supreme Court justices, Alito and Thomas, had been bought and paid for by billionaires like Harlan Crow, who, among other things I'll get to shortly, footed the bill for Justice Thomas's flights and private jets and lavish vacations. And not when these same dark money mega donors pushed radical, often unqualified judges onto the federal bench, further eroding the legitimacy of our court system. We all know that wealthy right-wing donors have increasingly formed covert operations using money and relationships with powerful people in Washington to support strategic litigation for Republican culture war causes, such as ending the acknowledgement of systemic racism in college admissions. One of these operations is Donors Trust, funded by a largely anonymous group of Republican mega donors, though it has been linked to major right-wing funders such as the Koch brothers and Leonard Leo. Professor Clark, why do you think dark money organizations such as Donors Trust want to hide where their money is coming from, and do you think that's ethical?
Congresswoman Lee, I believe that the record is rife with examples of wealthy trusts and institutions and foundations attempting to exercise influence and also attempting to hide their exercise of influence, because to the degree to which the public knows about it, there can be a backlash against it.
So throwing a stone and hiding her hand.
There's, I believe, a long record of that.
Thank you. According to their 2019 IRS filing, Students for Fair Admissions, the organization behind the end of affirmative action, received 65% of their funding from just 3 mega donors, including Donors Trust. Professor Clark, what are the ethical concerns of dark money groups, and do you think the affirmative action and student debt cases, for instance, ruled on this summer would have made it as far or been as successful without these donors?
Congresswoman Lee, I believe that dark money and hidden financial influences on our political system and on our judicial system can sort of undermine the ability of people at large to exercise their rights, participate. And so while this is not a matter of legal ethics as such, I think that scrutiny of how hidden large expenditures influence our political system and judicial system is important.
Thank you. In the last decade, billionaire hedge fund manager Paul Singer has contributed over $80 million to Republican political groups. Specifically, Singer gifted millions to the Manhattan Institute, a conservative think tank where he has served as chairman since 2008. The Institute regularly files front of the court or amicus briefs with the Supreme Court, at least 15 this term, including one asking the court to block student loan relief. Singer also gifted a luxury fishing trip to Alaska on a private jet to Supreme Court Justice Alito, who went on to decide the case blocking student loan relief for 40 million Americans, including me. So to sum all this up, back in 2009, as the Supreme Court prepared to decide Citizens United, one Nazi-obsessed vacation funding billionaire named Harlan Crow began funding Federalist Society leader Leonard Leo's scheme with Justice Thomas's wife to exploit the anticipated outcome of her husband's rulings. Their goal was to build a right-wing money machine allowing billionaires to fund changes to the judiciary and overturn years of judicial rulings they disagreed with, from abortion to environmental protections to LGBTQIA plus rights. One of these Leo and Koch-backed dark money operations, Donors Trust, then became the deep pockets funding the end of affirmative action decided by the court in July. And another billionaire hedge fund tycoon who flew another Supreme Court justice, Alito, to another luxury vacation via another private jet as he gave to another conservative think tank working to block Biden's student loan forgiveness plan, got his way to the cases before the Supreme Court that same day in July, blocking debt relief for 40 million Americans. To conclude, I want to say, like so many Black Americans, the one-two punch of student loan forgiveness and affirmative action designed to cement this country's already existing racial wealth gap left me feeling deflated, and they punched down on so much talent, so much brilliance by shutting Black students out. It leaves us feeling like we're running out of options, like we're powerless against those with endless money and power to rig our legal systems to benefit themselves. And yet, my Republican colleagues seem far more concerned with protecting Johnson & Johnson's ability to shield themselves against liability from their carcinogenic talcum powder that caused Black and brown women to develop ovarian cancer than protecting the American people against the capture of our courts by dark money networks and the business of selling out our freedoms in exchange for control of our
The
judiciary.
gentlelady's time is up.
Thank
We're over.
you, but
Thank
someone
you.
went 23
You
seconds
sound
over
great.
last time.
I know, you
Ms.
sound
Mace,
great.
But
You
the
sound
last
great.
chair went 23 seconds
45
over.
seconds
You
over
just used
time.
15
You're
of those
fantastic.
seconds for
We're
me.
over. We're done here.
I
We're
just want to make
moving
sure
on.
that we're fair.
Okay, I would like to recognize my fellow congressman from South Carolina, Representative Timmons.
Thank you, Madam Chair. Professor Steinitz, litigation funders are waging litigation campaigns even when there is, at least occasionally, no basis for liability. How are they able to make money if there's no factual basis for the lawsuit? And can you give us some examples of this?
Well, in funding individual cases, there's generally no money to be made from funding non-meritorious cases or cases without a factual basis. But when cases are aggregated, either through the mass or class tort system or through portfolios, it's possible to increase profitability just by increasing the size of the pool. And it can be hard to figure out for defendants how many of these cases are meritorious and which are not, and so that increases the leverage.
And that increases the potential liability and therefore increases the incentive to settle for some amount, regardless of the facts of the case.
It increases leverage against defendants, yes.
So the English law system has loser pays. A number of states have either adopted in part or in whole loser pays systems. Would it be reasonable for Congress to consider some sort of a loser pays model if certain thresholds are met?
I think that loser pay would be an overkill, quite frankly.
I'm not saying across the board, but if you, so you would just be opposed to any kind of a loser pays model at the federal level entirely?
I would have to think more closely about whether there's a way to tailor it to mass actions where there's there's been a finding.
Okay.
That funding has.
Does anybody else want to comment on loser pays as it relates to this, or?
Congressman, I think one thing that we have to keep in mind is in mass torts, we're not talking about class actions, right? Where one decision affects the thousands of potentially similarly situated individuals. In mass tort litigations in the United States today, we're talking about tens, if not hundreds of thousands of claims amassed by lawyer advertising backed by litigation funding, the majority of which are meritless, even if you accept the premise that there is a probable claim.
Okay, thank you for that. Could you give an estimate on the legal costs Johnson & Johnson typically incurs when defending against a mass tort claim, Ms. Wine?
Congressman, it is a difficult question to answer, particularly because each claim is different in size and mass. However, we do publicly disclose that. I mean, we publicly disclose our litigation expenses in our public filings. The one thing that's very interesting about disclosure is that in a litigation, defendants are required to disclose their insurance coverage under Rule 26. Plaintiff lawyers aren't required to disclose their third-party litigation funding. So equity parity in that space is what we're talking about here. We're talking about transparency. We're talking about disclosure. We're talking about regulating the ethical and fiduciary obligation between the funder and ultimately the claimant.
What other avenues would you suggest Congress go down to curb the incentive structure for filing these claims?
Congressman, I think there are a couple of areas to explore. The disclosure, transparency, ethical obligations, and third-party litigation funding is one. A second I would recommend is some regulation around attorney advertising. There is data that shows that the attorney advertising that occurs particularly with respect to medicines and medical devices harms patients, gets between the patient and doctor relationship, and actually can cause immediate harm to patients when they see these advertisements and get scared. There was a New York Times article in 2018 that I'd refer you to that talked about how plaintiff lawyers were contacting patients and encouraging them to get revision surgeries of their medical devices regardless of whether they needed them or not to create that mass. Another example I'd point you to is in an anticoagulant litigation where reports were submitted to FDA and the drug sponsor demonstrating that patients went off their anticoagulant medication because they saw lawyer ads on television. They went off that medication, and the immediate result of going off an anticoagulant is stroke or, unfortunately, death.
So my understanding is the attorney fee structure on these cases are fairly aggressive. Is attorney's fees structures an area that you would consider? Because, I mean, that is ultimately why they're pursuing these efforts, because they can make enormous amounts of money if successful.
Congressman, it is something that I think needs to be explored. If you think about the way mass torts are structured, ultimately what happens is a few cases are tried, but the thousands and thousands of cases that aren't tried but are parked in that litigation.
I don't want to get in trouble. Time's up. Thank you. I yield back.
Thank you, Mr. Timmons. All right, I'd like to recognize Congresswoman Crockett next for 5 minutes.
Thank you so much. I think my colleagues have made it clear that we have a corrupt Supreme Court, so I'm going to spare you on that part. I do want to make sure that people understand how confused I've been in this hearing. Number one, it sounds like my colleagues from across the aisle are somehow believing in climate change now, so I'm excited to hear this, because I thought it was a farce and a hoax, but we talking about renewables and we care, so that's really good that we got that going. Interestingly enough, I had the privilege, or maybe not so much, when I started my legal career, my first job was to actually defend a large pharmaceutical company. I hated practicing law. I decided I needed to do something else, and so most people only know me for doing civil rights or criminal defense or the things that really matter to individual people versus doing the bidding of large corporations. And so I want to walk through this just a little bit and lawyer out a little bit, because I'm going to tell you from the onset, one of my issues with this whole concept is, number one, we have a little thing called attorney-client privilege, and in my opinion, we are starting to get dangerously close to piercing that privilege, that relationship between the attorney and their client when you start saying, well, how are you funding this and things like that? Because let's say I'm using my own money, fine. Let's say I'm using a third party. Why is it that the opposition has the right to know what my strategy is, or why it is, or who's helping me to do what? That's number one. Number two, if we are complaining about frivolous lawsuits, we have a thing called sanctions. For the lawyers here, has anyone heard of sanctions? Please raise your hand. Okay, thank you. Have we heard of a thing called a 12B6 motion? This is for anyone that practices on the federal level, but it is a motion to dismiss that most defendants, unless you want to have a problem with your bar card, most defendants file a 12B6 motion to dismiss for failure to state a claim very early on if there is a problem with litigation. Is that true or not? Can I get a raised hand? Okay, all right, Ms. Clark agrees with me. So part of my issue is that we have certain mechanisms in place already. And the only thing that we've talked about, or seemingly one of the things that's been an overarching theme today, has been about the client advertisement, talking about the commercials. But the cost of actually prosecuting a case is more than a commercial. In fact, a commercial is not necessarily required from my experience. I've only been out of practice for a little less than a year now. But has anyone ever been involved in a lawsuit, say Ms. Wine, where maybe an expert report was required?
Congresswoman, in most of the cases,
Especially mass tort.
Expert reports are required.
Okay.
In addition, in all mass tort cases today, millions, if not hundreds of millions of dollars are spent on advertising.
I hear you, because you have made that clear, but the reality is that people use third-party financing for things other than just advertising. And let me be clear, it's not just going to affect Johnson & Johnson, who last time I checked is doing okay on their profits, but as I switch over and talk about my life as a civil rights lawyer, a lot of times you have a family who has someone who has potentially been killed by law enforcement. And a lot of times, we don't necessarily have the money to front for all the experts that are required just for you to have your day in court. And so this has been couched as something frivolous, but if we want to be honest about it, it's my understanding that there was an $18.8 million verdict that was just handed down by a jury to a man in California against your corporation as it relates to talcum powder. That was just in July, I believe, of this year. And so this idea that the third-party financing or seeing something on TV somehow then validates the claim. They still have to go through court. They still have to have expert reports. They still have to have attorneys. They still have to make sure that they take depositions. They still have to go through the entire discovery process. And a lot of times, at least in my experience, when it comes to defense, you end up with so much paperwork that you may end up needing a doc review team to go through all of the paperwork that is thrown on a simple plaintiff that may not have a large law firm that is behind them. And so what we are doing is saying if you have money, then you can access justice in this country. But if you don't have money, oh well, because we want to make sure that we know where your money is coming from, and that's just not fair. And the one thing that justice is supposed to be, that unfortunately we still are trying to get to in this country, justice is supposed to be blind. And unfortunately, I believe that this is the wrong venue. This is also the wrong body, because we do have bar associations. We do have courts and judges that have the ability to issue sanctions, that have the ability to dismiss cases. And if we have some issues with the qualifications of judges, which I do, we know who we need to talk to about that as well. With that, I will yield.
Thank you. I would now yield 5 minutes to Congressman Frey.
Thank you, Madam Chair. You know, I wear, prior to Congress, I kind of have, I would say, an experience on both ends of this, right? Both as a practicing lawyer and as a member of the General Assembly. From a practicing standpoint, I often saw times where a client or a prospective client might actually have a really great case in whatever they're doing, but they don't have the financial means in which to challenge or to get to a trial. You always quote a fee based on what you think it might cost to get to a trial, because once you're in, it's oftentimes hard to get out as a lawyer if your client's not paying. On the flip side, in the State House, I saw times, in Ms. Mace's district as an example, where the state of South Carolina paid an environmental group $5 million not to challenge the dredging of the Port of Charleston. It was kind of a pre-suit agreement, and we've seen this a lot. We've seen where third parties, at least on the state policy side, where environmental groups will come in and challenge a permit for a road construction project, a construction of a shopping mall, whatever the issue is. And at least in South Carolina at that time, there were so many cases devoid of actual facts that if they were tried that day, if everything was on the table, they would have not succeeded on the merits. But it is always the threat of litigation, the threat of the delays in a project that really concern me. And so when we talk about third-party funding, you know, I'm kind of struck. Where do we find that balance where we get rid of the BS that's out there and get to the merits of a case, but also preserving, you know, quite frankly, a David versus Goliath type of mentality where you might have a great case and it needs to be litigated in the courts and you probably will prevail on the merits, but the financial costs, I mean, sometimes trials or courts turn into a war of attrition. Who has the most resources in which to succeed on the case? And so, to me, Ms. Steinitz, your testimony, you state that litigation funding is a utility and it can be used or abused depending on the context. Do you believe that there is a line that can be drawn around third-party funding, and if so, where might that be?
Well, there's a bundle of issues with respect to litigation funding. So one issue is disclosure, and that has to be context specific, and it may be best to empower, but also leave it to judges to tailor it to the specific context. There's issues with plaintiffs losing control, and that requires imposing ethical obligations on funders so that we have a realignment such that clients have the same...
Can you speak into the microphone,
yes,
please, so we can hear you?
So that, then I can't see the congressman, but yes. So that we have a realignment that we had before third-party funding entered into the space, so that whoever's on the plaintiff's side, lawyer and funding, has ethical obligations towards the party that they're funding. So that's another issue. So there's multiple issues that would need to be addressed.
Well, on the ethical thing, just curious, do you think that those exist right now on the defense side? So on the defense side, oftentimes you see maybe an insurance company come in. Do you think that their standards are very different than the plaintiff's world?
Yes, their standards are very different. The insurance company industry is heavily regulated, including through ethics and in certain circumstances fiduciary duties, and there's nothing equivalent to that on the plaintiff side.
You have proposed for both legislators and courts that there needs to be kind of a flexible, discretionary balancing test. Can you expand on that and what you mean by that?
Yes, with respect to disclosure, because disclosure can be a valuable tool to sort of understanding whether there's problems in terms of who's providing the funding or under what terms in some instances, but in other instances, disclosure can be used just for tactical reasons in order to make it more difficult for plaintiffs to pursue their case and figure out how much funding they have to just spend that money down. And so it's very hard, in fact impossible, to just draw a clear line that would be applicable and fair in all cases. So it's best to let judges and empower judges to balance the various private and public interest of all of the litigants and the court system with respect to the type of case that is before them.
Thank you. Ms. Wine, is it Wine or Ween?
It's Ween, Congress.
Ween, thank you. I want to ask you a question. Can you elaborate on the types of control that third parties often exert over the direction of a case?
Congressman, it's hard to tell you the answer to that question because we don't generally have access to the contracts that set forth those control provisions. But what I would say, in the interest of time, I direct you to the Cisco B. Burford case, which gives us some insight, the IMF Bentham Best Practices Guide, the White Lily case, the Bolling case. Those give us some insight into the control that can be exerted.
Thank you, Madam Chair, and with that, I yield my time.
Thank you. I'd now like to yield 5 minutes to my friend across the aisle, Mr. Moskowitz.
Thank you, Madam Chair. Appreciate it. It's a pleasure to be here at this lovely filler hearing. It's not gone, I don't think, exactly as my colleagues thought it would go. You know, sometimes when I sit here, I often think to myself, who's in the room when these things get planned out? And like let's decide who we're gonna call. I don't know, let me find some sympathetic people to bring to this hearing today. Let me find a giant bankrupt corporation. Let me find an oil guy to talk about the Gulf of Mexico 12 times and how our national parks are getting better because of the Gulf of Mexico. Not really during the BP oil spill, but we won't go into that. I mean, we talk about judicial activism. I mean, I often think to myself, like, what was it not judicial activism when we had a judge meet with U.S. senators and say privately that Roe v. Wade was precedent on precedent, and then go in front of the Senate under oath and say the same thing, and then in their very first time, right, take back a law that had been there for 50 years? That's not judicial activism. And by the way, it would be an anomaly, except it didn't happen once, it happened twice. 2 judges appointed by Donald Trump that went and met with senators and said Roe v. Wade was precedent on precedent, and then went in front of the Senate under oath and said the same thing, and then get on the court. And in their very first couple of years, what do? They get rid of a law that had been there for 50 years. And so listen, I'm more than happy to listen to the cries of judicial activism. But we can no longer sit here and just pick when we like it and when we don't because it fits the politics of our time or the narrative that we're interested in. We sit here and we hear about, transparency. We want judicial transparency. I mean, it's almost like when this hearing was decided, maybe it was so long ago now that it wasn't in the news. I mean, boy, judicial transparency is really timely. So yes, thank you for bringing that forward about transparency in the legal system. I'm not sure that the American people are wondering about third-party litigation funding, but they're definitely worried about transparency with the highest court in the land where there is no remedy when you have ethical violations other than impeaching a judge in the Senate. And so, listen, we should do a whole hearing on judicial transparency because I think it's timely. I think the American people want to hear about it. It's just fascinating to me as we continue to sit in these hearings in Oversight. I mean, we've had 9 months of hearings on a very specific topic. Those have gone so well. We're now we're going to rebrand those hearings and hit the video game reset button, start all over again, right? I mean, it's just interesting. We sit here, we hear our colleagues bring up certain things like, oh, the Biden family took money from a foreign entity, right? And it's just like, well, really? I mean, do they really not know that Jared Kushner took $2 billion from the Saudis? I mean, by the way, they go on Twitter and blame the Saudis for 9/11. But then Jared Kushner, who, by the way, was not a wealth expert before he worked in the White House, nor was he a Middle East expert before he worked there, gets $2 billion from the Saudis, and they don't have any questions. And I just think that the American people recognize that they have no credibility. It's why the stuff they've been selling in this committee for 9 months has not translated, which is why they got to start it all over again. You don't have any credibility when you only want to look at one side of the coin, right? And so, listen, I appreciate the time, Madam Chairwoman, but I just feel like I'm not going to beat up on you guys anymore. I think that it's been quite obvious that the way this hearing has gone. And so I want to thank all the witnesses for coming today. It's probably not what you bargained for, what they told you this would be like, but I appreciate you all for coming, and that I yield back.
Thank you. Appreciate that. And I will now recognize myself for 5 minutes. It has been an interesting hearing. It's been a race of how many times can you say the word Donald Trump? It's just Trump this, Trump that, Harlan Crow this, Harlan Crow that, Justice Thomas. And then we just heard the Kushners. If the left wanted to investigate Jared Kushner, they had the White House, the House, and the Senate. They had every ability to do that in the last Congress, and they chose not to. So I have very little patience for that. And, how many times is the left going to talk about dark money? Well, let me tell you, Joe Biden is the definition of dark money. How much money did his family get paid off, and how are his bills paid? And we're not starting over with an impeachment inquiry. An impeachment inquiry actually expands our subpoena power and would allow us to hopefully get more access to more bank records to prove out the SARS reports, which we are not allowed to share. And that is the elephant in the room. Joe Biden got bribed, and it was to the tune of millions and millions of dollars, and the left wants to normalize the bullshit of bribery. Like, I just cannot get over the fact that we're going to normalize this and we're calling Joe Biden's bribery, quote, a specific topic. No, it's bribery. It's money laundering. It's prostitution rings, and I'm not a conspiracy theorist for putting these theories out there. Our investigation, there is evidence, and it's not, you know, hard evidence is what they're saying now. They're moving the goalpost from, oh, we just need evidence now. Oh, you need hard evidence. You don't have it. There are texts. There are emails. There are phone calls. There are lies that Joe Biden has told. Every single time the president has been asked about these bribery allegations, the guy has lied to the American people. He's lied to the mainstream media, and the mainstream media and the left just want to sweep this under the rug and pretend it's not happened. And it has. And this committee will continue its investigation. We'll have the impeachment inquiry, and we will ultimately get to the bottom of it, because the American people deserve the truth and nothing but the truth. And you shouldn't trust our words of Congress up here. Trust the evidence that has come out. Look at it for yourself. Look at the fact that there were over 50 intel officers that wrote a letter, put it on paper, and lied to the American people to tell you the laptop was fake. The laptop was real. And like, I'm just tired of the bullshit. I know the American people are tired of the bullshit. It is time to tell the American people the truth, no matter your political affiliation or party. It does not matter. And so I wish that we could be nonpartisan in the way that we do this. I wish that we could call out both sides. I'm someone who has called out my party. I have voted to hold my own party in contempt before Congress. I have dealt with the fallout from that because I'm calling the balls and strikes. And it would be really great if both sides of the aisle could do the same thing as well. So with that, I will try to get back on topic here and ask a few questions of our witnesses today, and I will try to pull them up. I want to talk about EVs just a little bit. In Charleston, South Carolina, in the Low Country in South Carolina, we rely on fossil fuels for our vehicles. We also rely on electric vehicles. I have both. And my first question I would like to ask Ms. Lucas is that EVs require 6 times more critical minerals than their internal combustion engine counterparts. Due to skyrocketing global demand for these resources, the prices of components necessary to produce an EV battery rose 200% in 2022. So if domestic mining projects are halted due to ongoing litigation, which is happening, how will this impact the prices of vehicles for consumers looking to purchase an EV, in your opinion?
Every mile that those minerals have to travel is extra cost. Every mile that those minerals have to travel is extra CO2 into the atmosphere. So the cost isn't just about what we as consumers pay. Mm-hmm. The cost is what our conscience pays as who is digging those minerals up out of the ground and what protections are in place. The true cost of our consumerism, it's not as simple as the cost of the vehicle.
And then critical minerals are used in infrastructure projects as well, like electrical transmission lines. How could increased mineral prices impact electricity prices for consumers?
As we look at transitioning our nation to one powered more by clean energy, the solar panels and the windmills are going to be put in places where the energy is not necessarily being used. So we are going to have to increase transmission lines across our country, and copper is the metal of electrification. It is the one that carries. So we can expect that those costs will increase as we need to bring in more of those minerals into the supply chain.
All right, thank you. And one last note of business, I'd like to say thank you to the many groups and organizations that reached out in anticipation of this hearing today with letters outlining their stances on the issue. I'd like to enter into the record letters to the committee from the American Tort Reform Association, American Property Casualty Insurance Association, the Advanced Medical Technology Association, the Institute for Legal Reform, the International Legal Finance Association, National Association of Manufacturers, Jerry Theododro at the R Street Institute. Without objection, so ordered. All right. And then, okay. I would now like to yield 5 minutes to Ms. Ocasio-Cortez.
Thank you, and I thank for the listing of all the special interests involved in addition in this hearing. Now, when I first heard that the Republican side was going to be calling a hearing on third-party influence in our courts, I was so excited because I thought, finally, we are going to address the biggest scandal in American democracy that we are currently having right now, which is the extraordinary corruption and wholesale purchase of members of the Supreme Court. And I also find it amusing that we just heard from the Republican side, why do we want to talk about this? Because women have lost the right to choose, because Indigenous people have lost rights, because minorities have lost rights, because working people across the country have lost rights due to this level of corruption. And if we're going to talk about third parties, let's talk about the Federalist Society, which has not only had deep ties to Justice Clarence Thomas and his wife Ginny, but has also helped choose judicial nominees for the Republican Party and directed multi-million-dollar media campaigns to confirm them, including a multi-million-dollar media campaign for Justice Alito, who seems to like using the Wall Street Journal as his personal press secretary. But I want to dig into a little bit about the influence here. In 2008, Leonard Leo, who's the head of the, who has ties to the Federalist Society, also organized a luxury fishing trip to Alaska, inviting a billionaire to join, Paul Singer. And when Paul Singer accepted, Leo asked if he could fly Justice Alito on his private jet to Alaska. So right here is Paul Singer, a multi-billionaire and a head of a hedge fund, works in hedge funds. And here is Supreme Court Justice Samuel Alito, AKA one of the justices turning over student loan cancellation, turning over women's rights to choose over their own body, and more. Now, Professor Clark, are you familiar with 5 U.S. Code 13104?
I'm so sorry, 5 U.S.C.
13104.
Is that the new codification of the Ethics in Government Act?
Yes, it's specifically on, and it requires reporting and disclosure requirements to government officials, yes.
Yes.
And I want to draw attention to 13104A2A. This section requires disclosure of the identity of the source, a brief description, and a value of all gifts exceeding minimum value. Professor Clark, are you aware how much the minimal value of gifts was in 2008?
I would guess it would be about $400.
Yeah, a little bit under $335 is the amount of gifts in gifts that Supreme Court justices are allowed to receive, which is actually balling compared to members of Congress. We only are allowed to receive gifts under $50. So the Supreme Court, you can give them free AirPods, you can give them really nice dinners, and they don't have to report any of that. But so we're clear, any gifts above that do need to be disclosed, correct?
Correct.
Yet, according to ProPublica's reporting, Justice Alito was flown on a private jet on this luxury trip, and if he had chartered a similar jet, it would have cost more than $100,000 each way, $100,000. Now, Professor Clark, with the cost of about $100,000 per flight, would Justice Scalia be required to disclose this trip?
I believe you're referring to Justice Alito.
Alito, yes.
And yes, under the Ethics in Government Act, disclosure would be required.
And did he?
My understanding is that he did not.
He did not. So we have a billionaire who runs a hedge fund with business before the court. In fact, we saw several cases before the court. And on top of that, he also had 3 days at a luxury retreat, which would charge over $1,000 a night. And he didn't disclose that either. Now, in the years since, we've actually seen the billionaire who generously sponsored this trip, Paul Singer, did business before the court at least 10 times in cases where the legal press and mainstream media often covered his role. So it was publicly known that he had business before the court. And in 2014, in fact, Justice Samuel Alito, along with the court, agreed to resolve a vital issue in a decades-long battle between Singer's hedge fund and the nation of Argentina. And do you know if Alito recused himself from this case?
I believe he did not.
He did not recuse himself from this case. And in fact, he used his seat on the Supreme Court after all of this to rule in Singer's favor. And following the decision, Mr. Singer's hedge fund was ultimately paid $2.4 billion because of this ruling. Not a bad return on investment for a fishing trip there. Now, Professor Clark, would a federal judge in a lower court be required to recuse himself?
The gentlelady's time has expired.
May I answer the question, sir?
I think the discretion of the chair, yes, you can answer
Thank
the
you,
question.
sir. Yes, there's a federal statute, I believe it's 28 U.S.C. 455, that does require recusal by both justices and judges under certain circumstances.
Thank you, and I yield back.
Thank you. The chair now recognizes the gentleman from Tennessee, Mr. Burchett, for 5 minutes.
Thank you, Mr. Chairman. Professor Steinitz, did I get that right, ma'am? Is your mic turned on?
Yes, sir.
Okay, thank you. And don't call me sir, ma'am. You're fine. Got to call these other knuckleheads sir and ma'am, but just I'm good with Tim. Thank you. Are there federal laws that are requiring the disclosure of third-party litigation financing?
Currently, there are no laws that directly require that, no.
Do you know the total number of litigation investors operate in the U.S.?
No, the total number is not known.
Okay. Do you generally know the rate of return for these investors?
No, that's also private information.
Okay. Do you know the total amount of funding in the third-party litigation financing industry?
There are only estimates.
Just estimates.
Correct.
Would you share some of those estimates with us? Or are you allowed to, that'd be, I'm not a lawyer. I know there's a word for it. I've seen it on television, but guessing or something. I'm not guessing, but all right. Well, Professor, let me ask you this. Have you heard of a company called Burford Capital?
I have, yes.
Yes, ma'am. Are you aware that in 2018, Burford Capital reached an agreement with a sovereign wealth fund to provide over $1 billion in capital for Burford's litigation investments?
I have seen a press release, yes.
So what these folks do is they just invest in these things and hoping for a return, obviously.
Correct.
Yes, ma'am. So foreign countries can fund U.S. litigation.
They can invest in third-party funders that invest in litigation in the U.S., yes.
Yes, ma'am. So would this mean that foreign adversaries and other bad actors could potentially exploit our litigation system to advance their home industries?
Potentially, yes.
Could litigation funded by foreign adversaries potentially delay technology critical to national security?
Potentially, yes.
Could third-party litigation funding potentially allow foreign adversaries to access privileged information?
Potentially, yes.
Without federal litigation or regulations, excuse me, is it possible to determine the extent to which non-U.S. persons or entities are engaged in third-party litigation funding?
No, without regulation, there's no way to do so.
Okay. Okay, Professor, let me ask you this. Are you aware in 2018 that the Biden administration settled a lawsuit with the Sierra Club and other environmental groups that sued the National Marine Fisheries Service?
I am not familiar with that, no.
Okay, you know who pays when the government settles a lawsuit with a plaintiff?
The taxpayer.
The taxpayers, yes, ma'am, thank you. See, that was called a leading question. If you didn't know that, I do know that. In cases where a plaintiff successfully sues the government, who pays the judgment?
Successfully sues the government, the taxpayer ultimately.
Yes, ma'am. So foreign adversaries and other bad actors could fund litigation threatening national security and then have it paid off by the American taxpayer.
If they're litigating or funding litigation against the U.S. government, yes.
Okay. Ms. Lucas, you're an environmental scientist, is that correct?
Water resources, sir.
Okay. But you would consider yourself a scientist?
Yes.
All right, good. Do you have concerns that some of the financiers of these lawsuits, especially those that claim to litigate in the name of climate justice, could actually be negatively impacting the environment in the long run?
That is one of my concerns, that we will not get up to speed in time to meet our goals of the Paris Agreement. We will not meet our goals for the U.S., and we will not meet our goals internally for our state that has set a 100% clean energy goal by 2040.
Okay.
We need minerals to build those materials.
Right. Ms. Wine, let's get that name right. Wine. Ween or Wine?
Congressman Ween.
Ween, Ms. Ween. What would be the long-term impacts of our economy if this broad network of activists went unchecked and its billions of dollars spent annually weren't disclosed?
Congressman, I think we're seeing it now, right? We are seeing the amassing of litigation, of unmeritorious claims, resulting in multi-billion-dollar settlements, money that could be used to further innovation, funds that could be used to further science, funds in our case that could be used to change health for humanity, which is what the thousands of people employed by Johnson & Johnson try to do every day.
Okay. Thank you, ma'am. Thank you, panelists. Mr. Chairman.
Thank you, sir. The chair now recognizes Ms. Porter from California for 5 minutes.
Thank you very much. Ms. Ween, in your testimony, you describe some of the hardships of this kind of litigation onto a company like Johnson & Johnson. Would you say that these kinds of mass tort claims are expensive to defend?
Yes, Congresswoman.
And to the tune of maybe even tens of millions of dollars, $10 to $20 million a month in expenses?
It's hard to say. Each one is different.
But millions.
Yes, Congresswoman.
Has it had an effect on Johnson & Johnson's overarching financial position, its stock price, its bottom line, its ability to invest in life-saving R&D, for example?
Congresswoman, every expense has an impact. And so while I can't quantify it for you right now, it does have an impact.
Johnson & Johnson, in its public security filings, in 2019 disclosed $1.2 billion in loans and notes payable, normal debt. In 2020, it disclosed $2.6 billion, almost double, more than double. In 2023, that amount had jumped to $11.7 billion. So Johnson & Johnson is taking on more loans over time, more notes, more debt over time. Has any of that been at all driven or related to the expenses, the incredible hardship that you describe of defending against these claims?
Congresswoman, while I couldn't specifically answer that question for you, I think it's interesting to note that we disclose our expenses, we disclose our source of revenue. The difference between third-party litigation funding and the defense of these cases is that there are no disclosure requirements there. There's no transparency there.
Oh, so Ms. Ween, you disclose, Johnson & Johnson discloses the names and terms and details of its loans?
Congresswoman, that's not what I said. I said that we make our public disclosures as required by the SEC rules.
Yeah, but all you disclose is the amount of the debt. You don't give any details about the names and terms. I mean, Johnson & Johnson backed LTL in the subsidiary that it created to the tune of a $61 million funding agreement that J&J, when it did the Texas two-step and split it into two companies, one with the assets and one with the liabilities, you entered into a $61 million funding agreement. Did you disclose the terms of that?
Congresswoman.
LTL was in bankruptcy.
Correct.
LTL's funding was coming from J&J. Did you disclose the terms of the $61 million funding agreement?
Congresswoman, unfortunately, I don't have an answer to that question for you right now. I'm happy to take it back.
Haven't J&J lawyers insisted that the sworn deposition testimony about that financing agreement be deemed confidential? Haven't they argued that to Judge Kaplan in New Jersey and the bankruptcy court, that LTL management, your subsidiaries' funding and financing for the purpose of defeating this litigation must be kept confidential, even as you sit here today and try to tell us that the plaintiffs should have to disclose all of the details of their financing?
Congresswoman, respectfully, I think that we're talking past each other. I think those are two different things.
Why?
Funding agreement related to the structure of bankruptcy As I understand it, we're talking about.
But the bankruptcy, excuse me, Ms. Ween, the bankruptcy only exists, and LTL management as a company only exists as a response to the talc litigation. It didn't exist until you tried to defend against the talc lawsuits. J&J was the third-party funder of the LTL company that went into bankruptcy to deal with the talc claims, and you argue, your company argued in court that those should be confidential. And yet, you want the other side, the plaintiff side, to have to disclose all of their funding. I think that's hypocritical. I think it is the same.
Congressman, respectfully, I disagree. I don't think it's the same.
Why?
Because as I explained previously, one has to do with the filing of bankruptcy and the funding agreement related thereto. The other has to do with the pursuit of third-party litigation funding that is intended.
J&J, pursuant to the bankruptcy, J&J was a different entity than LTL. That was your choice. That was your structuring choice, to split those companies and create two separate entities, which made J&J a third-party funder of the LTL litigation.
Congresswoman, respectfully, I disagree. It related to the filing of a bankruptcy plan.
Okay, I yield back.
Gentlelady yields. The chair now recognizes the gentlelady from Colorado, Ms. Boebert, for 5 minutes.
Thank you, Mr. Chairman, and thank you to our witnesses who have joined us today. Ms. Clark, in your testimony, you agree that third-party litigation funding does pose ethical risks, such as conflicts of interest, correct?
Correct.
Fantastic. Then why did you spend most of the time off topic discussing the, quote, ethics crisis, end quote, currently facing the Supreme Court?
Congressman Boebert, I believe that relative to the ethics challenges in the third-party litigation funding context, the crisis, the ethics crisis at the Supreme Court is much more grave and significant.
Thank you, Ms. Clark. What really it sounds like is an ethical concern to me is the constant wave of frivolous litigation from environmental extremists that deprive communities of employment opportunities, improvements to outdated infrastructure, cheaper products, corporate tax revenue, and economic certainty. So now, Ms. Clark, are you familiar with Earth Rights International?
I am not.
EIR is representing Boulder County in a lawsuit against ExxonMobil and Suncor Energy to, quote, recover the costs associated with climate change impacts. Now, would you happen to know who might fund Earth Rights International? Not knowing of the group, maybe you don't know exactly who funds this group.
Correct.
Correct. So EIR is funded by several wealthy anti-oil and gas funds, including George Soros's Open Society Foundations, the Rockefeller Family Fund, the Rockefeller Brothers Fund, and the Tides Foundation. In this lawsuit specifically in Boulder County, the Rockefellers have provided direct funding to the lawyers in this case. Another outside organization supporting the plaintiffs received a $200,000 grant from the Rockefeller Brothers Fund less than 2 months before the lawsuit was filed. Ms. Clark, do you find it at all concerning that these extreme environmental groups are attempting to circumvent this body by legislating via lawsuit?
Anytime a third party has a financial arrangement to finance legal fees, there is a potential for conflict of interest, and there are rules to address it. But beyond that, I'm not familiar with this particular group.
So I would see this as them attempting to circumvent this very body, just via lawsuit and our legislative process. In this Soros-funded lawsuit, ERI is making a baseless claim that oil companies are responsible for the destructive wildfires ravaging across my home state without a single mention of the several wilderness area designations. Now, a wilderness area designation prevents us from actually managing our forests, and they make it impossible, in fact, to actively manage that land. These policy decisions are debated and discussed by experts in congressional committees, which Democrats and Republicans agree we need to actively manage our forests, and that's why the founders gave this authority to Congress, not the Rockefeller families, to sue job creators, to shut down operations that will only hold up critical energy development projects for years, especially in my state, increase project costs, contribute to skyrocketing gas prices, and discourages future development. My communities that I represent in Colorado's 3rd District are literally being regulated into poverty because of these extremist environmentalist groups and their lawsuits that are circumventing our job here in Congress. Now, Ms. Clark, do you know how many jobs depend on the survival of the oil and gas industry?
I do not.
The oil and gas sector supports 69,000 direct jobs and 271,000 indirect jobs in my home state of Colorado. These are very good jobs. They're good paying jobs. And out west, George Soros and the Rockefeller families are trying to destroy in an attempt to legislate through the courts. This is a huge problem, and if they fail, at least they can go home as winners with a taxpayer-funded settlement. Do you know how much money federal government agencies spend settling these ridiculous lawsuits?
May I answer?
Yes, you can.
I do not know.
So former Director Ash testified that the agency spent approximately 75% of its listing program budget on, quote, substantive actions required by court orders or settlement agreements from litigation. 75%. Now, that sounds like a very real ethics crisis to me, Ms. Clark. Mr. Chairman, I yield. Thank you.
Thank you. Pursuant to the previous order, the chair declares the committee in recess subject to the call of the chair. We plan to reconvene 10 minutes after votes. The committee stands in recess. Thank you, Mr. Chairman, and I thank our witnesses for being here. Before I dive into some of the issues that we have been called here to discuss today, I want to respond to my friend and colleague from South Carolina and some of her allegations and statements that she made about this so-called impeachment inquiry. I believe that she stated that Joe Biden got bribes, committed money laundering, and engaged in a prostitution ring. She says there are texts, emails, and phone calls. But then she says that we should trust the evidence itself. And with that, I agree, because the evidence itself shows absolutely no connection between Joe Biden and any of those allegations. So we are now entering into what is so-called an impeachment inquiry, ostensibly because the Republicans say they need more information, and that somehow by the Speaker of the House unilaterally declaring an investigation, an impeachment inquiry, that changes this committee's authority. It does not. This committee has been investigating these allegations for more than 8 months. This committee of House Republicans have obtained more than 12,000 documents, pages of bank records, more than 2,000 suspicious activity reports, numerous hours of witness testimony, texts, emails. And the problem they have is not that they can't get the evidence. The problem they have is that the evidence does not support their allegations. And so why are we going to spend the next few months on an bogus and sham impeachment inquiry? Because Donald Trump wants them to. And Donald Trump has been calling them and urging them to do it because he was impeached twice. One of those impeachments of Donald Trump was because he tried to extort the president of Ukraine to investigate Hunter Biden. The president of Ukraine refused. Unfortunately, House Republicans don't have the spine that President Zelensky has, and they are now doing Donald Trump's bidding. Let me move on to the topic today, and I know that my colleagues would like to narrowly focus this hearing on their sudden grave concerns about third-party litigation funding. That's right, my Republican colleagues are having a hearing to criticize and restrict the free market from investing in litigation. Well, how could that possibly be that the party of free markets would want to restrict the free market? Well, I know why. Because big corporations and special interests don't like the fact that independent investors can support litigation that otherwise would not be able to be brought because of the expense. And I also find it ironic that Republicans are criticizing third-party funding in legal proceedings when they themselves have engaged in the same kind of third-party funding. And I'd like to ask unanimous consent to introduce for the record an article entitled FBI Whistleblowers Admit Taking Money from Ex-Trump Official. We'll take that. Thank you, Mr. Chairman. Now, it's no surprise that the Republicans are doing the bidding of the same special interests who have been spending massive amounts of money, of dark money, to control the Supreme Court. But the odd thing is that we're here talking about the ethical issues of third-party litigation funding and not the ethical issues in the Supreme Court. In June, I led a letter of 18 former prosecutors and law enforcement officials urging the Chief Justice to abide by his own declaration that he would take care of these ethics concerns, and saying that if he were to do that appropriately and seriously, he would first have to establish an independent investigative body within the court that can provide transparency and accountability, and two, that he would have to establish a dedicated ethics council to provide advice to the justices on their ethical issues. Unfortunately, his response to that letter just simply thanked me for writing it. And that's not good enough. And so my time is up, but I would urge my colleagues on the other side of the aisle who ostensibly are concerned with ethics that they hold a hearing on the dramatic and absurd ethical lapses of Supreme Court justices and make sure that we implement an ethics code on the Supreme Court, which are the only 9 justices in our entire federal judiciary who do not have to abide by our ethics code. And I yield back.
Mr. Turner.
Thank you, Mr. Chairman. Thank you all for being here. You got to pan the whole area to find me who's speaking, I know. We're gathered today to address a disturbing issue at the intersection of politics, activism, and corporate influence. The growing trend of liberal activists and private equity firms using dark money to fund frivolous lawsuits aimed at stifling industrial activity, political discourse, and civic engagement. A fundamental tenet of our legal system is that those who have been harmed can seek a remedy by bringing a claim to be adjudicated before the courts. When a remedy is obtained, it is supposed to go to those who are harmed. Increasingly, that is not the case in today's legal system, as some courts are being used to pursue social activism for special interests. Even more concerning is the fact that wealthy foreign actors with no skin in the game have begun backing scores of private law firms to sue American businesses for billions of dollars in damages. These payments mean the law firms have all their costs subsidized, and yet these same law firms are hired by state and local governments on a contingency fee basis. Ms. Steinitz, how are you today? Did I get it right, Steinitz?
You did, yes,
okay.
thank you.
Isn't it true that law firms receiving funding to cover their expenses and fees from wealth, special interest groups, who also get contingency fee agreements from local and state governments, have no risk while they stand to recover tens of millions of dollars, if not more, from contingency fee arrangements?
I'm not familiar with those arrangements, so I can't comment.
In recent years, a number of investors, including Arabella Advisors, George Soros, and Leonardo DiCaprio, as well as foreign funders like Christopher Hohn and Hans-Jörg Wyss, have funneled tens of millions of dollars into organizations that fund climate litigation targeting American energy producers. Ms. Steinitz, again, are you aware that several nonprofit organizations backed by Soros, DiCaprio, and Wyss, for which these wealthy individuals likely seek tax breaks, have also made donations directly to law firms that bring climate-related lawsuits?
I'm not familiar with that, sorry.
Not familiar with anything that I'm saying right now?
No, I'm afraid I'm not.
Okay. The Soros-backed New Venture Fund and the DiCaprio-backed Resources Legacy Fund have given millions of dollars to the California law firm Scher Edling, which is responsible for bringing over a dozen climate litigation cases. In addition to this special interest funding, Scher Edling is entering into fee agreements where it stands to make tens of millions of dollars. And it does not end there. Michael Bloomberg is funding a program through NYU Law where they place attorneys in state attorney general's offices, where those embedded attorneys are working on some of the same climate litigation where Scher Edling is also receiving a contingency fee. Ms. Steinitz, does that arrangement create concerns for you about the influence of wealthy special interests on litigation, purportedly brought on behalf of taxpayers, and who really plans to benefit?
Again, I'm not familiar with these particular arrangements, but the general point that we should be interested as a public in who influences the various branches of government, including the judiciary, is a point I agree with.
Thank you very much. Mr. Chairman, I yield back.
Thank you. Mr. Raskin.
Thank you kindly, Mr. Chairman. And I was glad that my colleague, Mr. Goldman from New York, was able to answer some of the surprising things that we heard from our esteemed colleague, Ms. Mace, right before we had our break. You know, it's very clear that Joe Biden is, that there's no evidence that has turned up over the last 7 months that Joe Biden is guilty of any criminal wrongdoing, any high crime and misdemeanor, much less prostitution, bribery, money laundering, or any of the crimes that were set forth in that laundry list that that Ms. Mace offered at the end. So I do hope she will clarify that. Let's see, Ms. Wayne, you're here as the Assistant General Counsel of Johnson & Johnson. Do I have that right?
Yes, sir.
And Johnson & Johnson paid $5 billion out in the opioid litigation and $4 billion in the talcum powder litigation. Is that right? Those numbers roughly correct?
Congressman, as far as I'm aware.
Okay. So are you here to complain about meritorious lawsuits being brought by consumers in cases like these, or frivolous and meritless cases being brought by consumers?
Congressman, an excellent point. We're not here to talk about limiting aggrieved consumers' access to justice. We're here to talk about transparency, regulation, disclosure around third-party litigation funding, which has an effect of actually diluting the claims that have merit with the influx of meritless lawsuits.
Okay, so you have no problem with the litigants who went to court in the opioid cases or in other mass toxic tort cases, the BP oil spill or the talcum powder case or so on?
Congressman, as a lawyer,
Yeah.
I believe in access to justice.
Gotcha. And there were no Rule 11 sanctions that your company sought against any of the litigants in those cases, right?
The ones that you mentioned, Congressman?
Yes.
Not as far as I'm aware. In the
Okay.
mass tort context, it's actually extremely different. Because we have no access to information regarding the thousands of claims brought against us, because plaintiffs aren't required to actually produce evidence of product usage or injury alleged from the product, we're essentially hamstrung from using Rule 11 to bring sanctions on those individual cases. We're also hamstrung in many cases from filing 12b6 motions, because that motion practice is usually suspended in the MDL process.
So you're saying you can't move to dismiss in a class action lawsuit?
Not a class action, Congressman, right? We're talking about multi-district litigation, which is a different animal.
Yeah.
Multi-district litigation, the aggregation of thousands of claims. Typically what we see are judges suspending motion practice, 12B, 12E, the usual discovery practices.
Yeah. Okay, well, that might be something interesting to look at, but to my understanding, anybody who brings vexatious, frivolous, or meritless litigation can be sanctioned by the courts. And, but I appreciate your candor in saying that that was not the case in the opioid litigation or in the talcum powder case.
What I said, Congressman, is that we believe in access to justice. So
Yeah.
those who brought those cases had their day in court. We don't stand in the way of that, of course.
Right.
And as I mentioned earlier, we don't believe that the talcum powder cases have merit. We believe that that is actually all driven by third-party litigation funding.
All right, fair enough. Well, maybe we should stop there because we're just going to disagree about that. And obviously, the settlement speaks for itself. One of our colleagues, actually several of our colleagues raised this issue, but one of them asked whether the Chinese government might have used intellectual property law or lawyers to achieve power over the U.S. government and to undermine American society. And I think I found at least one good answer to this question. And I'd like to submit for the record this November 6, 2018 Associated Press article headlined, "China Grants 18 Trademarks in 2 Months to Donald Trump and Daughter." In the early days of the Trump administration, Donald Trump and his daughter Ivanka got 18 trademarks from the Chinese government that she had been unable to get before, and there were lots of allegations about conflict of interest and influence peddling in the scheme. So I'd like to submit that for the record, Mr. Chairman.
Very good. Very good.
Yeah, I yield back. Thank you.
Thank you. Mr. Gosar.
Thank you. I first want to thank the Chairman Comer for this important hearing. You know, the thing I heard earlier was the gentlelady from New York claiming that this fishing trip cost $100,000 one way. That's got to be some kind of fishing trip, because that's not going to be $100,000 one way. It is vital that law firms and those who fund them put the interests of the victims first and not their bottom line. As a representative with a large mining constituency, I work hard to defend the mining industry from radical environmentalists and the woke third-party litigants who have funded them, whose goal is to end the mining in the United States. I also work very hard to make sure that the mining companies uphold their part of the bargain, that what they say they do, they follow through with that. One of the most egregious examples of third-party litigation funding that has yielded devastating consequences was the attempt by the Democrat Party prior to 2020 to change the voting laws. This practice was nothing less than the weaponization of the judicial system to overturn the will of the people as expressed in the voting laws created by their duly elected representatives. Mark Elias, the same man who hired Christopher Steele to lie about President Trump in an infamous dossier, who was sanctioned by a federal court in 2021 for misleading motion, was hired by the Democrat Party in 2020 to harass states by filing at least 50 lawsuits against them for laws seeking to preserve electoral integrity. Elias's law firm, Perkins Coie, received at least $41 million since 2019 from left-wing organizations. It is unclear how many millions the Democratic Party and their allies spent trying to destroy election integrity in the run-up to the 2020 elections. They should come clean and be transparent with the American people, and the same American people who I am sure they claim they are fighting for in their bogus lawsuits. Sound legal representation in any setting requires a moral compass that puts at first the interest of the injured party. Third-party funded litigants that have made half of our country doubt the integrity of our elections is unacceptable and is a very big stain on our country. Ms. Lucas, you're from a mining area, aren't you, from Minnesota?
Yes, I am, sir.
I've been up there. It's been very interesting. What are the average incomes of these smaller communities that have mining?
The average of that currently have mining?
Yeah.
I would have to get back to you on that one.
Would you say it's above 60,000?
The mining incomes are for sure above 60,000.
That's my whole point. I'm trying to get to those
Yes.
miners. This is if you can't mine it, you can't grow it, you can't fish it, you're not going to make a bunch of money off of it.
Correct.
How about the comparison of others in the state? They're much lower, aren't they, on average?
Yes, especially in rural areas.
Now, can you estimate the amount of state and federal permits and regulations a mining company may have to comply with to be able to operate in Minnesota?
It takes a lot of permits, and it should.
Yeah.
We have to have air permits, we have to have water permits, wetlands, land use, permit to mine, tailings basin, all of those things. It can be over 20 permits.
You know, we got Resolution Copper out in Arizona, and it's going on its 20th year. They've invested over $2 billion with a B, $billion in reclamation, and they still haven't got a permit. The water's cleaner coming out than going in. It's amazing what you have to do. Can you briefly describe how existing regulations encourage and require extensive community and stakeholder engagement to solicit feedback and address these concerns?
Yes, our system is set up to make sure that people know what's going to happen in their backyard. We need to have that system. It's important that we have that system. We have a legacy that demands we have that system. And every step along the way, from the beginning of the scoping EAW, through the EIS, through the permitting process, we ensure that we have multiple opportunities for the public to ask questions. If you live in a mining area, you understand mining, but quote unquote, normal people may not. So we need to provide all the opportunities people can get to ask those questions about what are you doing with our water? How will you protect our air? What will you do about wetlands? And we ensure we have all of those opportunities for people because it's a critical step in the process.
I get it. You think we can have our mining and have our cake and eat it too, right?
I think without mining, sir, we do not have this room that we are in. We do not have this building we are in. We do not have the lights on. We are not kept cool from the humidity that DC has. I thought we had bad humidity. I was wrong. But we don't have the world without mining, sir.
I absolutely agree with you. Thank you for your quest to keep mining a pivotal part of this economy. Thank you very much. I yield back.
Thank you. Ms. Green.
Thank you, Mr. Chairman. I agree that third-party litigation that is funded by groups that have interest in these issues is causing many frivolous lawsuits. I want to explain a situation that's happening in politics. Dark money-funded lawfare is waged against candidates, against groups to sway politics and also interfere in elections. On March 24th, 2022, a group called Free Speech for People, which is an ironic name, filed a lawsuit against me using the 14th Amendment to try to remove my name off the ballot in my district in Georgia. This group, Free Speech for People, has received funding from leftist groups like San Francisco Foundation, Kohlberg Foundation, Leonard and Sophie Davis Fund, Overbrook Foundation, Park Foundation, Schumann Media Center, and Cloud Mountain Foundation, and many more. These groups are groups that claim they care about defending democracy, but they funded a group called Free Speech for People that was interested in taking away the free speech of the voters in my district. These groups from San Francisco and New York, all they did was fund a group to interfere in an election in my district in Georgia. On April 22nd, I had to go to court where I took the witness stand defending myself under oath against a lie launched and funded by this dark money group and run by far-left political operatives like David Brock and Norm Eisen. But I won. And it cost me almost $1 million defending myself. And then 1 month later, I had my election day on May 24th, 2022. Well, I want to tell you I won again because the voters in my district voted for me with over 70%. But this is still happening, and it's happening again to interfere in the 2024 election. Last Wednesday, a lawsuit was filed by Citizens for Responsibility and Ethics in Washington, CREW, to have President Trump removed from Colorado's ballots over claims he violated Section 3 of the 14th Amendment on January 6th. This is the same thing Free Speech for People tried to do with me, and I beat them, and President Trump will beat them as well. CREW was founded in 2003 by Norm Eisen, the same activist that was probably involved funding mine, and Melanie Sloan, to be a progressive watchdog group. Democrat operative David Brock of Media Matters, also well known for the Brock Memo, was chairman of the board of directors from 2014 to 2017. Norm Eisen worked for the ADL in the 80s, investigating anti-Semitism and civil rights violation. He worked on his law school classmate Barack Obama's presidential campaign and then was named special counsel for ethics and government reform in the White House. In 2019, Eisen was appointed consultant to the House Judiciary Committee, where he worked on the first impeachment of President Trump. You can see where this goes, ladies and gentlemen. It's all about politics. Eisen implemented the David Brock blueprint for suing the president into paralysis and his allies into bankruptcy. He helped mainstream and amplify the Russia hoax. He drafted 10 articles of impeachment for the Democrats a full month before President Trump ever called the Ukrainian president in 2018. He personally served as special counsel litigating the Ukraine impeachment. He created a template for internet censorship of world leaders and a handbook for mass mobilizing racial justice protesters to overturn Democratic election results. There is perhaps no man alive with a more decorated resume for plots against President Trump than Norm Eisen. All of these actions were part of the David Brock memo, which outlined how to defeat President Trump through Lawfare, funded Lawfare. The next step is Eisen and Brock's plan is to take President Trump and his allies out before the presidential election of 2024. They're trying to use January 6th as the reason for filing lawsuits against President Trump in various states, arguing he violated the 14th Amendment and is supposedly guilty of some so-called insurrection that never was, and therefore would be ineligible to run for office. CREW, the organization Eisen founded and Brooke chaired, is one of the main groups devoting funds to this goal. We have to stop funded lawfare by political organizations that want to take away people's freedom of speech to vote for the candidate that they want to vote for. And we also have to stop these dark money funded groups from interfering in elections. I yield back, Mr. Chairman.
Thank you. If there's no further business without objection, the committee We have another show coming up afterwards, so we're going to not deal with the closing statements. If there's no further business without objection, the committee stands adjourned.
Sir, can you also say this?
And now it's the ATF. Except with the ATF, they don't even claim to be experts. The director said so last week. Last week in a hearing in front of Congress in the Appropriations Committee, he was asked about firearms. He said, I'm not an expert in firearms. Not an expert, but still trying to run Americans' lives. You would think the head of the agency tasked with regulating the entire firearms industry, a constitutionally protected industry, would know something about firearms. Earlier this year, the ATF issued a rule that unilaterally puts new restrictions on Second Amendment rights. This rule redefined firearms with stabilizing braces as short-barreled rifles so that they could be controlled under the Gun Control Act of 1968, the National Firearms Act of 1934. There are approximately 40 million firearms with stabilizing braces currently in circulation. The pistol brace was created for use by disabled persons, including disabled veterans. These individuals could lose the ability to use these tools and as a result, may not be able to operate their firearm. Under the new rule, these firearm owners will be required to obtain special registration, surrender or destroy their brace by the compliance date, or they will face severe criminal penalties. This is not the result of a decision made by Congress. Congress didn't change the law. No bill was introduced in this committee, passed by this committee, passed by the House, passed by the Senate, and signed by the President. Nope. This rule turns law-abiding gun owners into felons is a result of unelected bureaucrats simply enacting a new regulation. And that's not how it's supposed to work in our great country. Congress writes the laws and the executive branch enforces them. Here, the executive branch has taken power from Congress in deciding what the law should be, and that they charge themselves with enforcing, excuse me. Director Dettelbach has in essence become a one-man Congress. Notably, this decision runs counter to the ATF decision under President Obama in 2012 that a firearm equipped with a stabilizing brace was, quote, would not be subject to the National Firearms Act and those controls.